Hello everyone and welcome to this video tutorial on how to apply the law on implied terms to a contract law scenario. In this tutorial we're going to be looking at the Florence and the TV aerial scenario again, but this time we're going to be looking at it from the implied terms perspective. I've done a previous video tutorial on how to apply express terms where we also looked at this scenario but from a different angle. I do recommend that you watch the express terms video first and then come back to how to apply implied terms if you've not already done so. So in this tutorial, we're going to look at the Florence scenario, as I've said. We'll recap quickly what the law on implied terms is, and then we'll look at how we use that idea structure to get a really nice answer to this. Remember that contract terms is a really big topic, and it includes express terms, implied terms, exclusion clauses. Today we're just focusing on implied terms and how to apply the law just on that. But in the real exam, it's likely that you're going to have a much bigger scenario that maybe has got some express terms, some implied terms, maybe an exclusion clause or two in there as well. So you'd be doing maybe 3 ideas on one scenario, one of them being implied terms, for instance. So anyway, let's get on and focus on implied terms. Florence has arranged for James to install a TV aerial. James missed 2 appointments for which Florence had taken time off work. When he finally turned up for the 3rd appointment, James damaged the roof tiles when he dropped his tools whilst installing the aerial. Though the aerial was properly installed, the aerial was of poor quality and failed to improve the television reception in any way. TVs R Us have refused to accept any responsibility. And you're being asked here to advise Florence on whether there are any terms implied by law. And that's quite a nice question because it's telling you specifically what area of contract law you should be applying here, i.e. implied terms. But even if it just said advise Florence on what action she might take against TVs R Us, you should be able to recognise that this raises in contract law issues of implied terms. We've got missed appointments, we've got work that's been done shoddily, we've got mention of poor quality products. So I'm hoping you will be thinking anyway, even if you've not been told what to do, that that's implied terms. And we'll do a bit of a recap now of implied terms so that hopefully you can see what I'm talking about here, that those things hopefully would jump out at you when it's fresh in your mind. I've got a summary sheet here on implied terms. Remember that express terms are terms which are agreed by the parties themselves, either verbally or in writing, whereas implied terms are terms that have not been agreed by the parties themselves, but nonetheless the courts are implying them into the contract. And there are 2 types of term that are implied: terms implied by fact and terms implied by law. So terms implied by fact, to start off with then, these are based on the imputed intention of the parties. So basically the courts are putting words into the parties' mouths and are saying, I know the parties didn't agree to these terms expressly, either orally or in writing, but we believe they must have meant to include these terms in the contract because otherwise the contract wouldn't work properly. And in Marks and Spencer, the Supreme Court made it clear that they were quite reluctant to imply terms into a contract, and they would only do so for business efficacy or if the officious bystander test was met. So it approved both of these quite old tests. And to start off with then, the officious bystander test came from the case of Sherlaw. And the test here was, had an officious bystander been present at the time the contract was made and had suggested that such a term be included, it must be obvious that both parties would have agreed to it. And the business efficacy test comes from the ancient case of the Moorcock from 1889. And this asks whether the term was necessary to give the contract business efficacy, i.e., would the contract make business sense without it? And the courts will only apply a term where it's necessary to do so. So when we're looking at a scenario, we can think, do either of those situations apply, that it must have been needed for the contract to function? They're not as common. The more likely type of implied term that you're going to get really is a term implied by law. And this just means that the term is included into the contract because an Act of Parliament says so. And we've got a really important Act of Parliament here that you need to know, the Consumer Rights Act 2015. And this Act lists a whole host of implied terms that are put into every contract, regardless of the party's wishes. And it'd be useful for us to just quickly look at the slide that summarises some of the key provisions of the Consumer Rights Act 2015. So the 2015 Act implies certain terms into all contracts, that they should be of satisfactory quality, that goods should be fit for purpose, they should be as described. When services are being supplied, so you might have a plumber or a builder in your house, there is an implied term that they will use reasonable care and skill. So they're not going to use sticky tape to stick things together, for instance. It's an implied term that there will be a reasonable price and they'll complete it within a reasonable time. And there are also limitations under this Act on unfair terms. So it's really important for the exam that you've learnt these key sections so that you're able to apply them to a scenario. And hopefully now we've had this quick refresher, things like satisfactory quality are leaping out at you now, because if we go back to the Florence scenario, you can see here that the scenario said it was of poor quality. So if you're really familiar with the Consumer Rights Act, that would have jumped out at you and you think, oh, it might conflict with Section 9. Other things that might have jumped out at you here is the fact that James has missed 2 appointments. So when we looked at that previous slide, it said that work would be carried out within a reasonable amount of time. So could we maybe say that it wasn't a reasonable amount of time because he's missed 2 appointments? And then we've got the issue here of James damaging roof tiles when he dropped his tools. So he's damaged something there. So could that maybe indicate that he's not using reasonable care and skill doing his job? So in terms of implied terms, we now know the issues that are relevant to Florence, so we need to look at how we would structure our answer to maximise our marks on this. This slide here, I've broken down how you would apply the law on implied terms. Using IDEA, as always, we identify, define, explain and apply. So you would start off by saying that your claimant, in our case Florence, might be able to rely on terms implied by the courts or terms implied by statute to assist them with their case. And then in terms of definition, defining implied terms, I've said the terms set out the obligations under a contract. Terms can be express or implied. Implied terms are not agreed by the parties themselves, but are implied into the contract by fact or by law. And they're taken to be as effective as if they'd been included from day one of the contract. And then in your E, you are going to explain the 2 types of implied term using your cases. And there isn't an awful lot to write here on implied terms, but remember that in a scenario, you'll probably have done an idea on express terms and maybe exclusion clauses as well. So that's why this is a little bit shorter perhaps than we're used to. You will have other ideas in there as well. In terms of applying implied terms, if relevant to your scenario, they're not really relevant to Florence, so we're not going to mention them in our application. but in other situations they might be, and you would apply the officious bystander and the business efficacy tests. More likely, you need to say whether any implied terms from the the Consumer Rights Act 2015 apply to your scenario. And on my next slide, I've done a bullet point answer to the Florence implied term situation. We've already sort of gone through the I, the D and the E. In terms of application then, mine's very bullet pointy. Remember, in the exam, you're going to write in full sentences, explaining yourself clearly. This is just so that it would all fit on one slide. So what I've said is, even if the aerial company has not expressly made terms about the aerial, terms might have implied by statute. Consumer Rights Act section 9.1 implies a term that the goods are of satisfactory quality. And it said in the scenario, even though it had been properly installed, it still didn't really work. So we can say that if the aerial's not of satisfactory quality, this will mean there's been a breach of this implied term. We could also say if the aerial isn't actually helping TV reception, section 10 applies as well, because section 10 implies a term that the goods will be fit for purpose. And clearly, a TV aerial that doesn't improve reception is not fit for purpose. So again, we could rely on that section. Section 49 says that work will be carried out with reasonable care and skill. We could talk about the fact that maybe James might have breached this by dropping his tools. But to be honest with you, I don't think that's really significant enough. Anyone can drop something. I probably wouldn't think that's enough for section 49. And equally, section 52, we could argue maybe that he's missed appointments, so maybe he's breaching the implied term that it should be carried out within a reasonable time frame. Again, although we can make that argument and you'll pick up good application marks for saying it might be relevant, because it might be, depends how the judge feels, it's unlikely. 2 missed appointments probably won't breach it. If the scenario had said something like it took James 15 months to get to a house, I mean, obviously that wouldn't be a reasonable time. But 2 missed appointments, if he's very busy, that's probably not going to be enough. But, and I should have really put a conclusion here, you can definitely do it. Her best bet is to rely on Consumer Rights Act Section 9 and Section 10, because whether the aerial company likes it or not, there are implied terms that it is of satisfactory quality and fit for purpose. And so she'll be able to claim for breach of contract if it is not. So I hope that's been helpful in helping you to see how you would apply the law on implied terms to a scenario. Please make sure you have watched my other video tutorials on how to apply express terms and exclusion clauses, because as I keep saying, terms is a huge topic and it's likely that you will get multiple issues, not just implied terms in a scenario. So please watch the other videos as well.